All right, so the way we're going to handle this is, and I'm speaking to the board members here, is that we have a proposed rule around describing exceptions for abortion. I'm sorry, I'm just kind of pulling this up here. Okay, so to kind of lay out how this whole process has worked, there is a law that is passed, or that has been passed. There have been questions that were asked around certain processes or how exceptions are defined. And that question came up in a court ruling also, which ended up going to the Texas Supreme Court. And the Texas Supreme Court gave some suggestions that the medical board can give guidance on this issue. Initially, of course, as there were a lot of pending litigation going on out there, we needed to hold off on doing anything until we got some direction from our counsel as to what we can or what we cannot do from that standpoint. In the meantime, there was a petition that was entered for a rule, that was made for a rule. And by law, when a petition is made, the board has 60 days to consider the petition for rulemaking. And with that, we are able to look at all the legal factors that are around it and make a decision as to whether we will or we will not adopt a rule. The decision was made that we would put a rule for consideration to the board and that we would discuss it here today, and based on that, make a recommendation on whether we approve it as is or with modifications, or to not approve it. When or if it gets approved, it would go out for public comment. That public comment would last a period of 30 days. As the board would meet afterwards, we would take all those public comments into consideration, and we can either modify the original board rule as it was adopted for consideration, or we could make substantive changes. If substantive changes are made, again, based on additional input, then it would have to actually go out for additional public comment. If there are no substantive changes that are made, the board rule at that point could potentially be adopted and finalized. So this process, at a minimum, would take until the next board meeting. But depending on how we decide to change things at the next board meeting, it potentially could go on to another board meeting after that. So in general, that's how the process works. I think there's a couple of things that I had mentioned earlier on as far as considerations that we did as far as the rule is before I actually read it out. Number one, as I had mentioned before, because there was pending litigation around the issue, the Attorney General's office was consulted on this issue prior to the rule language considered. This does not mean that they agree or don't agree with it, but they have seen the rule, they understand it, they've seen it, and they've been able to weigh in and make suggestions as they are also represent us as a board when there are other issues that are out there. Additionally, speaking from that standpoint, I had mentioned earlier on, but not all of you may have been here, but there is language that came specifically from the Supreme Court that I think it's important for all our licensees to know, but more importantly for the public to know. And again, specifically, and I'll read out the language from the Supreme Court language itself. It says, a woman who meets the medical necessity exception need not seek a court order to obtain an abortion. Under the law, it is a doctor who must decide that a woman is suffering from a life-threatening condition during a pregnancy. Raising the necessity for an abortion to save her life or to prevent impairment of a major bodily function, the law leaves to physicians, not judges, both the discretion and the responsibility to exercise their reasonable medical judgment given the unique facts and circumstances of each patient. I would remind everyone that this is directly language from the Supreme Court ruling itself. So as we talk about the language of the rule, I just want to make sure that those 2 points are clear and that they're out there. And as I said earlier, the medical board will issue a press release that goes into a little bit more detail on our consideration and the process itself. So with that, typically we don't necessarily read proposed rules in detail line by line, but in this case, I will. and then I will move it to deliberations between the board members after that. So this is Chapter 165, Medical Records, Subchapter B, Exceptions to Abortion Ban. 165.7, Definitions. The following words and terms, when used in this subchapter, shall have the following meanings. Abortion means the act of using or prescribing an instrument, a drug, a medicine, or any other substance, device, or means with the intent to cause the death of an unborn child of a woman known to be pregnant. The term does not include birth control devices or oral contraceptives. An act is not an abortion if the act is done with the intent to A, save the life or preserve the health of an unborn child, B, remove a dead unborn child whose death was caused by spontaneous abortion, or C, remove an ectopic pregnancy. The definition is found at Chapter 25, Section 245.0021 of the Texas Health and Safety Code. Ectopic pregnancy means the implantation of a fertilized egg or embryo outside the uterus. And removing an ectopic pregnancy is not an abortion. This definition is found at Chapter 245, Section 245.0024A of the Texas Health and Safety Code. 3. Reasonable medical judgment means medical judgment made by a reasonably prudent physician knowledgeable about a case and the treatment possibilities for the medical conditions involved. This definition is found at Chapter 170A, Section 170A.0014 of the Health and Safety Code. Medical emergency, number 4, means a life-threatening physical condition aggravated by, caused by, or arising from a pregnancy that, as certified by a physician, places the woman in danger of death or a serious risk of substantial impairment of a major bodily function unless an abortion is performed. This definition is found at Chapter 171, Section 171.0023 of the Texas Health and Safety Code. Number 5, major bodily function includes, but is not limited to, functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. This definition is found at Chapter 21, Section 21.00211A of the Texas Labor Code. 165.8, abortion ban exception performances and documentation. And I believe this is the second part of the rule. A, an abortion shall not be performed in this state unless it is performed in compliance with all provisions of Texas Health and Safety Code Chapters 170, 170A, and 171, in addition to any other applicable federal and state statutes, rules, and court opinions. B, in addition to the requirements above, the physician must specifically document in the patient's medical record, 1, that the abortion is performed in response to a medical emergency. A, underneath 1, that places the woman in danger of death unless the abortion is performed or induced, or B, to prevent a serious risk of substantial impairment of a major bodily function of the patient unless the abortion is performed or induced. Number 2, the major bodily function or functions at serious risk of substantial impairment. 3, what placed the woman in danger of death or what was the serious risk of substantial impairment. 4, how the danger of death or serious risk was determined. 5, how the decision was made to proceed with an abortion based on reasonable medical judgment, including A, what diagnostic imaging, test results, medical literature, second opinions, and or medical ethics committees that were used or consulted, and B, what alternative treatments were attempted and failed or were ruled out. Number 6, how determination was made that performing a procedure in such a way as to give the child the best opportunity to survive would create a greater risk to the woman. And 7, whether there was adequate time to transfer the patient by any means available to a facility or physician with a higher level of care or expertise to avoid performing an abortion. The third section, 165.9, complaints regarding abortions performed. A, the Texas Medical Board will review complaints and perform investigations regarding abortions using the board's standard complaint process. B, if a complaint is determined to be jurisdictional to the board will use independent expert physicians as provided in Texas Occupations Code, section 154.0561, to review the available information, including the patient's medical record. C, any decision by the board to either dismiss the complaint or discipline the physician who is the subject of a complaint is separate and independent of any other possible criminal or civil action under the law. If the board is aware the licensee is subject to a pending criminal or civil action, then the board may defer or delay action. Depending on the outcome of criminal or civil action, Texas Medical Board retains the authority to investigate and potentially take disciplinary action. That is the text of the rule. I'm now going to open it up to the board members to ask questions and to deliberate between us as board members.
I have a question.
Dr. Quinones.
In section 165.7 under definitions, item 1, abortion. Item B, remove a dead unborn child whose death was caused by spontaneous abortion. Should that not be spontaneous fetal demise?
The specific language is coming directly from chapter 245.
Okay.
So that's how the statute is worded.
Okay.
And again, for clarification, these definitions were put in here because some of them were things that people would come to the board and ask some questions about. Well, what about an ectopic pregnancy? What about, if the fetus has already expired? What is reasonable medical judgment? What isn't a medical emergency? What is a major bodily function? And so we try to put all that stuff together in one place to make it easier for people to see and to make it clear that this is what the board will be looking at as far as definitions for those terms.
Okay.
One other thing that I will just go ahead and state here, and I understand that there was a desire to have a list of potential conditions that would fall under these definitions. We've had this experience somewhat with COVID, where we were looking at conditions that would meet the criteria for not allowing elective surgeries. And it was very difficult for us to go down that path. We actually put out FAQs at the time, but we also still, in spite of that, we're getting a lot of questions about different circumstances out there that frankly we could not anticipate or really get into the minutia of every single case. The reason it's difficult to actually adjudicate that is because you can have a very similar condition, but depending on the other circumstances that are going on with that case, and that's why we have expert panelists that look at that. Medical judgment is really not whittled down to a list of conditions. You're really looking at the totality of an issue that goes beyond a specific circumstance. I understand it may be easy that, you may have a chromosomal abnormality. We can list a couple of things here and there. But when you do that, it becomes difficult to go into what may not have been listed. So if this specific one wasn't listed, does that mean that that is not qualified? You have to go back and actually redo all the rules again. Did you not anticipate this one specific circumstance? Things may change as far as what medicine can do to save a baby's life. So a condition that may apply now may not necessarily apply later on. And as the Supreme Court ruling said, it really defers to medical judgment based on what the standard of care is out there in the community based on specific and certain conditions. And as such, you can't put a list out there that defines what medical judgment may or may not be with every single circumstance that's out there, because not every circumstance is exactly the same. You can have two conditions, but two very different circumstances, including where it may have happened. Was it in an area where you could not transfer the mother to an area of higher level of care? And that was actually included in the rules as to whether that was possible or not, which of course would have to be very specifically documented. So given that kind of circumstance, you can have a condition that would be potentially looked at one way in one scenario, but the exact same condition in a different scenario looked at in a different way. And you actually cause more harm by listing conditions without understanding the nuances. You restrict what our expert panelists would be able to do and what they would potentially be able to determine without looking at all those specific circumstances. So from that standpoint, restating definitions that are already in the statutes and explaining what the process of how we would deal with a complaint, which primarily is, again, going to our expert panelists, which, as you may have heard earlier on, are physicians out in the community or experts in the specific field who can look at a case in an exhaustive way, look at all the circumstances, look at the medical records, look at the documentation, look at the nuances, look at the mitigating factors, and come up with a recommendation to the medical board. And the way that process works is that we have two expert panelists that are typically looking at it. If they are unanimous in their recommendation from the standpoint of standard of care, it comes directly to the medical board that way, whether it's unanimous in saying that the standard of care was met or whether it was unanimous in saying that standard of care was not met. If the two of them disagree, it goes to a third expert panelist that goes into a lot of detail as to what their recommendation would be. And at the end of the day, again, it comes to the medical board as a whole. We hear it as a whole, and we can opine on it. Even when we make a determination if something was followed as we think it should have or not, even that can be appealed and go to SOA, which is the State Office of Administrative Hearings, as you have seen earlier today with those two proposals for decision. When it goes to a SOA hearing, it goes to an administrative law judge that looks at the findings of fact. In those instances, both sides can actually provide more evidence. There's discovery. It's a full-blown court process hearing. The PFD, proposal for decision that is given by that judge, comes back to the medical board, and we as a medical board are confined by the findings of fact that the judge has determined. And again, that is based on expert panelists, expert witnesses, that was heard on both sides. And from that standpoint, we are able to look at those specific findings of fact, and we can make a judgment specifically based on those findings of fact. We can't change the findings of fact, but we may or may not have discretion depending on what that is. As I said earlier, if it's a felony conviction, for example, we don't have discretion. But in other instances, we have discretion. There may be instances where we would have to refer it to law enforcement. There may be instances where it may involve an institution, and we refer it to another state agency if it's not involving specifically a physician, or if it's involving another licensee. For example, if it's a nurse practitioner, it may involve the nursing board. If it's a physician assistant who are operating under prescriptive authority, it would fall under the medical board because physician assistants are under the medical board. So again, just kind of going back to that whole overall process is that giving an exhaustive list, we felt, again, this is up for debate. I'm sure we're going to hear a lot of comments as public comment comes out in the next 30 days. And this is something that we will look at and we will debate again, and we can deliberate on, and we can make a decision. But that is the overall arching theme from our standpoint as to why we were very hesitant into putting an exhaustive list out there, that in fact it would hinder the ability of specific circumstances to be looked at in a way that would be fair to both parties.
Yeah, and to expand on that a little more, when it comes to taking our cues from the Supreme Court opinion in the Cox case, again, as you read out about, it doesn't take a court order to do one of these procedures, and it's left up to the judgment of a physician. And then also the court in their footnote talking about how the board put out some guidance when it came to elective and non-elective procedures during the COVID pandemic. So we took both of those cues, and that's kind of also what helped model what we have here as far as a rule. It talks about it is the physician's decision, and if the physician is going to do this, these are the things that need to be documented. And just like in COVID, we did not put out an exhaustive list to say these type of procedures are elective and these are non-elective. It was up to the physician to make that call. Just be sure and document why you did what you did in that circumstance. And so that's, again, what you're seeing here.
And of course, we defined what that process is as far as a physician looking at the different issues that are out there. And again, it's about documenting the Cox case very specifically really centered around a documentation issue. And this really highlights to our own physicians that it's extremely important to, number one, make that judgment based on the criteria that we've laid out, based on the definitions that we've laid out that are coming specifically from statute, and making a judgment based on that. Frankly speaking, our belief as a board is that anything that goes beyond that is outside of our jurisdiction. That for us to opine beyond those certain set of circumstances as defined by law would really have to be something that would be addressed by the legislature. We can only do so much. We can define what the process is. We can put definitions out there as far as medical emergencies and other nuances that are out there. We can describe what the process is that we go through when somebody raises a question as to what that looks like. But we can't define things like rape and incest being a certain condition. That is not under our jurisdiction. We can't go into very specific circumstances that are not listed in these definitions or that are not specifically listed in law. The only way that that can be dealt with, one way or the other, is by legislative action. We as an executive agency, as part of the executive branch, our ability to do anything is to enforce the law as it's written. We do have some discretion as to help define what the law says, and help to expand on how the process works, but we do not have discretion in rewriting the law or changing certain provisions of the law. That has to be a legislative action. So with that, any other questions from the board members? Any suggestions for, or any questions about certain language? Any suggestions for changes? Okay, if there isn't any, is there a motion out there?
I'll make a motion.
Dr. Bhatia?
Motion to accept subchapter B, exceptions to abortion ban as
Excuse me, Doctor.
we say as elaborated by Dr. Zafran just now.
Okay, there's been a motion made by Dr. Bhatia. It's been seconded by Mr. Kokonos.
And
Is there
Dr.
any
Zafran,
discussion?
Dr.
Yes, Mr.
Zafran, let me jump in and clarify. Dr. Bhatti, your motion is to publish the rule in the Texas Register as was read out and proposed by Dr. Zafran. That's what you want to do, right? Is to publish it in the register for the comment period.
For the comments to arrive. Yes, that's correct.
Okay.
All right, thank you.
Yes, to make that clear, we are not adopting a rule. We are publishing a rule for comment. And then if there's going to be consideration of adopting a rule, it would be based on deliberation at the next meeting, as I mentioned earlier, after looking at the public comments, deciding if there's going to be any changes. If it's substantive changes, then it would need to go out for public comment again. So you've heard the motion from Dr. Bhatia. There's been a second by Mr. Kokonos. Is there any further
Can I get a
discussion? Ms. Morgan.
clarification? So this is out for public comment for
Okay.
how long?
The public comment is for 30 days.
Okay,
The minimum of
It's-
30 days.
So it
okay.
can be actually
Minimum
up
of-
to the next board meeting.
Yeah.
Yeah.
so
It's
minimum-
it's a
in
minimum-
the registry for public comments.
It will go out to the registry
Yeah.
as soon as they put it out into the public registry, which I think is fairly soon. And then when it's out in the public registry, it will be out there for public comment no less than 30 days. We meet again in June, which is more than 30 days. So at that point, it could be worth 90 days worth of public comments. But that is the soonest that we will deliberate it, unless for some unforeseen reason we decide to have an emergency board meeting exactly 30 days from now. I can almost assure you that won't happen. But it will be at the next board meeting that we would further consider this proposed rule. Right? Any other questions?
And Dr. Zafran, just so the board members are clear, and Mr. Carlton, I think you hit on that. Yes, Ms. Morgan, the law requires that it be put in the Texas Register. It is a minimum of 30 days. It can be extended, as Dr. Zafran said. There is also the potential, and I think Dr. Zafran, you mentioned this morning, and I think it's important
Stakeholder meeting.
that there's the potential for a stakeholder meeting. I think we're planning at least one to be sure we get input. Then the process goes, as you said, Dr. Zafran. We as board staff will assemble the comments. We'll look at those. If there's anything that may need to be changed, modified, it will be brought back to you as a board. So there's a number of steps that will occur between now and the next board meeting if we get there, including, as I said, the stakeholder meeting. The other thing is, and Mr. Carlton, you may want to talk to the individuals that are at the meeting, that we have also, will have a link on our website if the rule is in fact adopted with the pending motion. It's going to be on our website. There's going to be a link with a comment form to facilitate your comments that you can go on and click and fill it out for the board. So those will be assembled for my staff and my office along with the board, literally almost automatically because we've got the form there. So we may want to cover that in a bit.
Yeah, absolutely. That is something I was going to cover before we begin the public comment portion of it.
Brent, can you just please help explain to everybody how we're going to announce the stakeholder meeting? Yeah, like we said, there's going to be at least one. Again, depending on how that goes, there may be additional ones, but that will certainly be announced.
Do you want me to cover that now or
Yeah,
do
go
the
ahead and
motion?
cover it now.
Okay. So stakeholder meetings are an opportunity to have, kind of like we're doing here. It can be in person and hybrid and virtual also, and have individuals take that opportunity to provide comments to the board and to board staff. We will have at least one of those. We may have more than one, depending on the amount of comments we get and requests that we get for stakeholder meetings. Obviously, we want to get as much input as we can from the public on it. Whenever it comes time for doing comments, it really is most beneficial to the board when those comments are submitted in writing. It's also okay if you want to appear and kind of read through your comments that you're presenting in writing. And then there could be an opportunity for a back and forth, not in this forum for this meeting because it's a public comment period that we're going to get to in like a kind of a normal open meeting. But when you have a stakeholder meeting, you have more of an opportunity for a dialogue back and forth to ask questions and get clarification. But again, it is really most helpful for the board if we get the comments in writing, either through the web form that is going to be on our website, and we're going to try to put as much information on our website as possible to help you guys stay informed of where we are in the process and the current information. Again, all that will not hit the website until the board actually votes to adopt publication of the rule. But again, we will have more than one, at least one, probably more than one stakeholder meeting. Again, this may take a while to go through the entire process through the Administrative Procedures Act. The board does have to review every single comment that we get. We need to respond to every comment that we get. So this may take many months, and in all likelihood will probably extend past the June board meeting, possibly into August or even October.
All right, so there's a pending motion out there. Any further discussion? All those in favor, please say aye.
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 All those opposed? Are there any abstentions? All right, the motion to publish the rule passes.